This is one of the most important technology-related cases the Supreme Court has ever heard. This is a case that flows from an appeal from the Second Circuit Court of Appeals, where the federal government was not successful in enforcing a search warrant against Microsoft. This is not an easy issue. The data at issue is not stored in a server in the United States. The data is in a server in Dublin, Ireland. They argue there is no federal authority as a matter of law where the government is allowed to go in and enforce a subpoena inside the United States to compel acquiring data that's residing in a server outside of the United States. This case is a really big deal for not only consumers, but for companies big and small located principally in the United States, but really all over the world. It's a question of whether the federal government, with just the stroke of a pen, has the power to access your data and companies' data, regardless of where it is on the planet. This is really not at its core a constitutional case. This is a technology case involving borders and data security. And that's why it's so critical that individuals and companies in the United States and all over the world really keep a very close eye on this. The decision's coming out at the end of June. This is going to have a major impact regardless of what side of the fence anybody is looking at as they wait for the Supreme Court's decision. If the Congress enacts the Cloud Act, which it may or may not do, that is supposed to create a reasonable balancing of interests between the domestic need for law enforcement and search warrants against the local particularities and the needs of the data storage abroad. It is a sophisticated statute, it's supported by both parties, and it's still under debate.